Hello everyone, welcome to our channel once again. Please leave a like on this video and subscribe to our channel for more updates, and also leave a comment to express your thoughts on this. The presidential candidate of the People's Democratic Party in the last presidential election, Alhaji Atiku Abubakar, has again pleaded with the Supreme Court to jettison technicality and grant his application for leave to tender fresh and additional evidence to support his claim that President Bola Tinubu submitted a forged document to the Independent National Electoral Commission to contest the February 25th presidential election. Atiku predicated his plea on the grounds that presenting forged documents by any candidate, especially by a candidate for the highest office in the land, is a very grave constitutional issue that must not be encouraged. The former vice president stated this in his reply on point of law to Tinubu's objection to the grant of leave to Atiku to present the fresh evidence before the apex court. Tinubu had predicated that his objection on grounds of jurisdiction and that the issue of qualification is a pre-election matter, among others, and subsequently prayed the court to deny the grant of the application. But in his reply on point of law, Atiku, while faulting Tinubu, submitted that issues of merit ought not to be determined or pronounced upon at the interlocutory stage. The applicants, while noting that they are only at this stage merely applying for leave of the Supreme Court, is to receive the fresh evidence, submit that to refuse to grant the leave, as the respondents have argued, will amount to undue technicality. The Supreme Court, as the apex court, and indeed the policy court, has intervened time and again to do substantial justice in such matters of great constitutional importance, as it did in the case of Amechi versus INEC 2008, 5 NWRL 227, and Obi versus INEC 2007, 11 NWLR 565. The Supreme Court applied the principle of ubi jus ubi remedium to ensure substantial justice is done in such novel scenarios. The need to rebuff, eschew, and reject technicality and the duty of court to ensure substantial justice is very germane in this matter. Given the gravity of the constitutional issue involved in deciding whether a candidate for the highest office in the land, the office of president of the country, presented a forged certificate or not. In urging the Honorable Court to overrule the objections of the respondents, we can do no better than to commend to your noble lordships the insightful words of the Supreme Court in ASA and ORS v. Kara and ORS 2014 LPELR 24212 SC per Rhodes Vivo JSC as follows. Law is blind, it has no eyes, it cannot see. That explains why a statue of a woman with her eyes closed, covered, can be found in front of some high courts. On the contrary, justice is not blind. It has many eyes. It sees, and sees very well. The aim of courts is to do substantial justice between the parties, and any technicality that rears its ugly head to defeat the cause of justice will be rebuffed by the court. Meanwhile, in a 20-paragraph affidavit deposed to in support of the application, Atiku argued that if the apex court grants the application, there would be no need for any further argument other than the written address in support of same, showing that the second respondent is in violation of the provisions of Section 137, subsection 1J of the Constitution by presenting a certificate disclaimed by the institution from where he purportedly procured same. The contrary of paragraph 16xi of the second respondent counter affidavit, there was no ex parte communication with the Honorable Court, but the letter was forwarded to the registrar of the court, just as was done in the case of Uzodinma v. Izunaso. The deponent, Mr. Uyigiwa Osage, further argued that Tinubu's objection was baseless because he was represented both at the discovery and the depositions, as well as at the court hearing by his Chicago attorneys, and that the second respondent never challenged the issue of venue of the discovery and deposition. That the presence of the first and third respondents at the discovery and deposition was not necessary. That I know that the second respondent appeal was to prevent the discovery and deposition, and that the appeal failed. Meanwhile, Atiku faulted Tinubu's submission that he was inconsistent in his names, describing the submission as immaterial and pedestrian as there is no petition challenging his qualification. Besides, Atiku pointed out that the presentation of a forged certificate disqualifies a candidate for all time, no matter when presented.